Welcome back to the Legal Alternative with Sam, joined as ever by Nils. Nils, how are you?
Very good, Sam. You have a good weekend?
I did. We'll talk about it a bit later, but yes, fresh off the plane. Can't miss the podcast though. So we've got lots to talk about today. You've got some visa, family issues. I'm going to kick us off with a bit of a chat about a disability discrimination case on the definition of disability. Bear with me, Nils. I'm going to do more reading than usual because it's quite technical, but actually really interesting EAT case. Case we're dealing with is a case called Steadman and Haven Leisure. And we're dealing with an EAT overturning an original decision of the tribunal on the definition of disability. And we've done a lot of case law recently dealing with process. We're going to talk technically about a definition now. It's an interesting case that I actually completely agree with the EAT. I think that the tribunal judgment was a bit of a bungle, but we'll go through it. So I'll give you the brief background and important for listeners to note, we've not got a primary decision here. So what we're talking about is actually a case that originally failed to meet the definition of a disability, therefore claim couldn't progress any further. Background to the case is that the claimant, Mr. Steadman, has two diagnoses of ASD, which is autism spectrum disorder, and ADHD, so attention deficit and hyperactive disorder. He's applied for a job as an animation host with Haven Leisure and has been unsuccessful in that application. He has claimed that that is because of his disability. And as I say, we don't have a primary decision of actually whether the disability was the reason for him not getting the role. This has fallen down on the conditions, obviously, that Mr. Steadman had, not amounting to a disability under the Section 6 of the Equality Act. So whilst I know you know it well, for our listeners, Equality Act Section 6 defines a disability as a physical or mental impairment which has a substantial and long-term adverse effect on the individual's ability to carry out their normal day-to-day activities. And this is where the definition in the eyes of the tribunal has not been met. So in his claim, Mr. Steadman says he faced day-to-day challenges, including forming friendships, using public transport, communicating with colleagues. He provided a medical evidence from his consultant psychiatrist who provided a diagnosis of ASD and ADHD. However, the tribunal originally determined that Mr. Steadman was not disabled for the purpose of the Act, in that although the reported difficulties of day-to-day activities were one that the tribunal defines as what one might expect from someone who is not disabled. The judge noted that Mr. Steadman had completed a degree and BTEC examinations, and there were suggestions that he exaggerated some issues with reading and writing. The tribunal therefore concluded that Mr. Steadman's difficulties with day-to-day activities is one might expect from someone who is not disabled. So, other people would struggle with those day-to-day activities. Therefore, didn't meet the definition, and therefore the claim fails at that point. We've then had that appealed to the Employment Appeals Tribunal, who have held that the ET has not deemed and not applied the appropriate legal test to the definition on 3 grounds. So they've said that the decision the claimant did not have a disability was perverse in the light of the contents of the medical report. So in the original ET, they've relied more on the individual's impact statement as the primary evidence of that disability. Because of the impact statement, they've said it's not met. And the EATs said it is perverse to not rely on the consultant's medical report that this person obviously has those 2 medical conditions. The second reason for the appeal being successful is that the judges said the ET has failed to recognise Mr. Steadman's difficulty in forming friendships and his inability to using public transport when they're looking at that substantial adverse impact. So the day-to-day impact, they've not considered those 2 items as part of that. The third element, and I think helpfully summarise it for me, that the judge was wrong to focus on what Mr. Steadman can do rather than what he cannot do. So they've looked at his degrees, they've looked at the fact he can do things actually more than what they've looked at what he can't do. So on the basis of those three reasons, they've upheld his appeal. The outcome, in that the employment judge's decision was totally flawed and required the matter to be resubmitted to the tribunal. So it's gone back in to the tribunal. Personally, I think this claim the critical element is not for me. I think the EAT was absolutely right in that respect. Obviously, what we don't know and what we can report back on is ultimately the next stage of that. Is the reason that Mr. Steadman has not got the role because of his disability?
Yeah.
So we've focused, and apologies, quite technical area there, but I think even on the basis of that, I think it does seem perverse that you've got a report from a consultant psychiatrist saying these people have the clear disabilities, and then the judge is focused more on the kind of impact statement and his views, something I'd always would suggest would be controversial. So bit of a technical one for me this week, but I don't know any thoughts from you.
I think this thing was quite strong language to say totally flawed. So I've never dealt much with EAT decisions. In fact, I can only think when I did just employment, I can only think we appealed once in my entire career, but I think that's quite strong language, isn't it?
Yeah.
The other is, does this decision sort of mean that once you've got a positive medical report, it's going to be quite difficult to move away from that, because that's going to be the primary piece of evidence, and to go against the medical evidence is probably always going to be quite difficult.
Yeah. And again, we've not been involved in how this claim has been defended and has been brought. From my own experience, I'm surprised that the disability was contested. Obviously, the solicitors defending Haven in the first instance were clearly right to do so. They've obviously in the first instance they've had the claim, they've succeeded in the claim. But my experience generally of that is when you've got a report clearly labelling these two issues, I would normally be conceding a disability in those. It's for our listeners, it's quite hard to take complete takeaways at this case, because I know it is technical. And if I was advising litigation, I would be advising my clients to accept that this person is disabled. Obviously, that doesn't mean he has to be successful in the job. It's that next stage that's going to be critical. But an interesting thing, we don't always get into the detail of medical definitions, so something I wanted to share.
Is that Haven the popular caravan?
It is.
Yeah.
So obviously, let's say his role was
animation host. So I'm assuming that's someone who does the sort of kids' mini discos, that sort of stuff. Yeah.
So that's me for this week. I think visas.
Good stuff. Yeah. Continuing the visa themes, and purely because we're dealing with this a lot at the moment. Just wanted to talk about what the process is for people who are in a relationship with somebody who is likely to ascertain a visa or already has a visa, but they weren't married.
Yeah.
Not only were they not married, but they're unable to show that they lived together for 2 years. Yeah. So if an individual, for example, the sports clubs that we work for, if they've got a visa, or you've got a skilled worker visa for if you're a non-sporting club, it might be you want to bring a dependent with you. Yeah. Definition of dependent is husband, wife, civil partner, or a married partner, and it's that last one that we're going to be focusing on. So if you're if you're married, the easiest way to show that you're dependent would be your marriage certificate, civil partner certificate for a marriage that's recognised in the UK. If you've been living together for 2 years as well, that's fairly easy to prove. Show the rental statement, the utility bills, or something along that line. It gets a bit more complicated when you're in a relationship, which a lot of people are, but you don't actually live together. And you're not able to show that you've been living together for 2 years. Particularly if you're at the start of your career, it might be that you've been in a relationship with somebody for 18 months and only living together for the last 6 months, which I would imagine is fairly common. So if you've been in a relationship for at least 2 years, but you can't show that you've been living together, it's about how you show that. And the UKVI guidance is saying, was it because you were working somewhere else? Because you've been studying in different places? So it might be you've just fresh out of university. Or is it because it's not actually accepted within the culture that you're part of to live together until you're married? So if you fall into that category, where you've not been living together for 2 years, you need to prove what's called ongoing commitment. So examples UKVI give: can you show that you've been communicating regularly with each other? Can you show that you support each other financially? Care for any children that you have together, and spending time together as a couple, for example, on holiday or at events. It's actually more difficult than you might think to do a lot of that. And I think the key point I would make to people who might be in that scenario is, if you can be organised, it speeds the process up. So if you know you've got to provide this information, going back what might be a number of years to show the ongoing commitment that you've got, that makes it so much easier for us as lawyers. Things like joint wedding invites, your phone records, banking apps make it a lot easier to show transfers to and from one another, holidays together, photos on holiday. All these types of things contribute to building a picture. If you can do a supporting statement alongside that, I think generally you're going to be okay.
I guess lots of people, then there's some sensitivity and embarrassment sharing some of those things, messages in particular. I assume that there will be, but those are the rules. So a supporting statement, would that be could you get a supporting statement for someone else, or is it just
I usually do it from the individual, saying this is when we met, this is how we met, this is why we've been living apart, this is what we intend to do when we're in the UK, which will obviously be to live together, and just summarising the evidence that we've provided. So usually, as I say, at the moment anyway, to get lots of photos, bank statements, that type of thing, greetings cards to one another, all that type of thing. Some of it you're asking quite personal questions, but it's the only way. And it's got to be that 2-year period. You've not been together for 2 years. It's unfortunately not possible.
A lot of conversations about when someone would start a relationship or not. I think it's again, but as you said, I could imagine in terms of UKVI, it's not what they want to be looking into a lot. So if you can provide a professional statement, I can't imagine they want to delve into 2 years worth of messages, but that's what they'll have to do.
Not necessarily 2 years worth of but certainly a snapshot. So it might be, here's some phone calls between us in 2023, here's some photos of us together in 2022. I think the good thing, my experience at the moment, is this does tend to be at the younger end. The good thing with social media is there's lots out there for people to get quite easily.
I can imagine it's slightly rife for abuse in terms of that defining what a relationship is, essentially what the UKVI are doing, aren't they? So an interesting one, and as you say, a troubling one. And if that's what's required, people will have to provide that information. It's what you need to do.
I think this is when a lawyer's asking for, just don't panic. It is part of the normal process.
Exactly.
It may feel like you've been interrogated about your relationship, but it's better from us than the actual visa failing and everyone's wasted time and money.
I think exactly. I think that's right. It's clear. It's not what is said is not important. It's the length. It's the length of time.
Exactly.
An interesting one, and one I think, again, as you said, really relevant for what we're doing a lot of at the moment with our sports clubs. But obviously anyone knows, any skilled worker.
Exactly.
It's really, really common. Perfect. Out of the office, as I said. I've just been back from a weekend in Ibiza. So fresh. I think we had a 20-degree drop from 28 degrees in Ibiza to return to 8 in Leeds, Bradford. Came into Leeds Bradford Airport, which is still a bit of a shell. I don't know if you've been recently, Nils. It's been a bit of a building site. So you come out of arrivals. Imagine most airports, you come out of arrivals and you get into the lobby in Leeds, you come out into a car park.
It's weird, isn't it? I went to Dublin in August, and it's just, I did like they've opened a little bit of the new terminal, which is nice.
That's nice, but I just kind of arrived in the car park. I was like,
bizarre.
Yeah. So that's good. Also wanted to pitch on my end, seminar program, still going strong. So I think before last week's episode, as I mentioned, we had a seminar, some really good numbers in our Wakefield office, performance management. Got an employment update, one coming up next month, also in the Wakefield office. Again, details on the website and the mock tribunal. So events coming thick and fast. So any listeners not got any details, we'll put them in the bio and come on the website. It'd be great to see people getting along.
I had a university reunion.
Oh, yes, you did.
Newcastle over the weekend, which was fantastic. Made me feel very old because we went back to our old haunts, which is still occupied by students, and we worked out that we could actually have been fathers to these students, which is bonkers, but really enjoyed that. And I know we talk about sports law a lot on this podcast, but with it being both our passion, professional passion anyway, it would be remiss not to say commiserations to Leeds.
Yeah, I think I was good. I think he was good. I was in IB. I think I would be rather miserable if I wasn't. Yeah, a bit of an absolute gut crunch at the end.
Absolutely, but also commiserations to Bradford. I think that was a last minute loss as well, and also to Wakefield.
Have a good week.
I'm trying to think. Have we got any sports clubs left in?
No, I think we're not in rugby, so just all on football now.
Yeah, Huddersfield won at the weekend. I can't remember what Barnsley did, but I think they're still up there as well. So congratulations to them.
Perfect. That's it from this week. I think we'll be back next week and with more updates. So goodbye from me.
And from me.